Hello, my name is Ed Pappas, and I'm past president of the State Bar of Michigan and chairman emeritus of the Dickinson Wright Law Firm. I am pleased to invite you to watch this video presentation on Michigan's new limited scope practice rules, which became effective on January 1st of this year. The rules are an important development for the practice of law and the ability of lawyers to serve the public in more affordable ways. They allow attorneys to provide discreet legal services to clients, including, for example, assistance in preparation of pleadings or other legal documents, and limited appearances in court, at depositions, and at mediation. This not only provides access to legal representation to low and moderate income individuals who otherwise would not have access and who need limited assistance, but also presents an opportunity for attorneys to expand and build on their current practices with clients who can afford to pay for limited representation, but cannot afford to pay for full representation. Adopting rules like these was a priority recommendation of the 21st Century Practice Task Force, and I was honored to be a part of the small group that drafted the rules. I also had the privilege to present them to the Michigan Supreme Court for their adoption when they recently appeared on the court's administrative docket. Our first presenter, Christopher G. Hastings, who is a professor at Western Michigan University Cooley Law School, will walk us through the new rules with a helpful PowerPoint presentation. Among his many volunteer activities in his community and with the organized bar, Chris is a member of the State Bar's Professional Standards Steering Committee and a member and previous chair of the Bar's Unauthorized Practice of Law Committee. Chris was a member of the State Bar Work Group that developed the limited scope rules, and he was the primary drafter of the rules eventually adopted by the Michigan Supreme Court. We will also hear from Barbara Baker Omerod, a Shiawassee County private practitioner who has good ideas of how and why the new rules will help members of the public understand the value and affordability of legal services in today's marketplace. Barbara's practice focuses on probate and estate planning, Medicaid, family law, and bankruptcy. Barbara is also a member of the State Bar's Professional Standards Steering Committee and is co-chair of the Bar's Unauthorized Practice of Law Committee. Let's begin with Professor Hastings' presentation.
Hello, this is Chris Hastings, and I'm here to talk to you about the changes for 2018 to the Michigan Court Rules and the Michigan Rules of Professional Conduct that permit limited scope representation, also known as unbundling. In order to better serve clients who can't afford lawyers to handle an entire representation, the Supreme Court has given us two new tools for our toolbox. First, specific rule-based authority for ghostwriting court papers. You can write them, you don't have to sign them, your client can sign them and file them. Second, the ability in an appropriate circumstance to file a limited appearance rather than a general appearance and to withdraw from a limited appearance without seeking an order from the court allowing you to do so. If you want your own copy of the changes to the rules, and these are the changes we'll be talking about today, or the rules we'll be talking about, find some way to get this rather awkward URL into your web browser, and you can print your own copy of the rule changes. We'll be looking at first the changes to the rules of professional conduct, and then changes to the court rules. The centerpiece of the changes to the rules of professional conduct our new Michigan Rule of Professional Conduct 1.2b. Here you see the new rule in all of its glory with the strikeouts and the underlinings that we're so familiar with. What I'm going to do so that we can take a better look is I'm going to highlight each little chunk. I'm going to clean it up for you and present it in larger print so that we can talk about it. The main part of 1.02b allows us to limit the scope of a representation. We file a limited appearance and act as counsel of record for the purpose identified in that appearance. Now, there are two qualifiers here, and they're both important. First of all, in order to file a limited appearance and act in a limited scope, you have to make a determination that the limitation is reasonable under the circumstances. This requires investigating your client's circumstances, your client's abilities to self-represent, and making a determination that your role will further your client's legitimate objectives. Second of all, the client has to give informed consent. Well, how does your client give informed consent? Well, with information from you about the pitfalls of limited scope representation, and once they have those, they can not just say, okay, I agree, they can say, I understand and I agree. And you'll want to have that confirmation in writing. Let's look at the next chunk of the rule. There it is, cleaned up. A lawyer licensed to practice in Michigan may draft or partially draft court papers. You don't have to sign them. But what you have to do is you have to include in the document that you've drafted or helped draft a statement that it was drafted or partially drafted with the assistance of a Michigan lawyer. That enables the court, in appropriate circumstances, to make inquiry of the lawyer about what they've done. You get some protection, though. If we look at the next section, this piece right here, absolutely clear that filing the document that you've written is not an appearance by you. It's going to be signed by the party, not the lawyer. Plus, you get some relief from your usual obligations under the rules of professional conduct to do investigation. You are entitled to rely on your client's representation of the facts, unless something is jumping out at you as wrong, unless you have reason to believe that the representation is false, or the client seeks objectives that are inconsistent with your obligations under the rules of professional conduct, or that the claims or defenses are insufficient. You can rely upon your client's representation of the facts. Other changes to the Michigan Rules of Professional Conduct, we have some defined terms. Confirmed in writing is defined to say, gosh, you really need to get it in writing. You can operate for a short term under an oral consent, but you need to get the writing. It protects you. Second, we have a definition for informed consent that requires you to do a competent and thorough examination of the risks with your client so that the consent that they give you is actual informed consent. The final changes to MRPC 4.2 and 4.3 recognize that a limited scope appearance creates some challenges for the other lawyers in the case. For the duration of a limited scope appearance, the other lawyers will be serving both the limited scope attorney and the client. We also have a clarification that for purposes of contact, during the scope of the limited scope representation, clients aren't self-represented. During the limited scope representation, you're representing the client, so the other attorneys are going to be dealing with you and not with your client until the limited scope representation is terminated. Let's turn to the Michigan Court Rules. The centerpiece here is MCR 2.117B2. Now, I've cleared away all the things that we're not talking about so we can see this without the clutter. B2, Notice of Appearance, allows you to appear in a civil action for a limited purpose as long as you satisfy two conditions. First of all, you have to file and serve a notice of limited appearance. Second, and this is important, the notice of limited appearance needs to identify the limitation of the scope by date, time period, and or subject matter. You need to spend some time to make sure that your limited appearance has the limitation in it, because the protection you get comes from creating that limitation within your appearance and then staying in that lane that you've created. If you get out of that lane and you start doing things that are outside the scope of the appearance, there's the potential for trouble. And indeed, if we pull up the part of B2 that wouldn't fit on that first slide, we see in subsection D that an attorney who has filed a notice of limited appearance must restrict activities in accordance with that notice. Stay in your lane. If you exceed that scope, then the other lawyer by motion or the court by show cause order can set a hearing to establish the actual scope of the representation. You want to avoid that, just make sure that you stay in your lane. Here is the plum. An attorney who has filed a notice of limited appearance may withdraw by filing a notice of withdrawal. That's all you have to do. File it, serve it, and provided your client signs it, it's effective immediately. Now, sometimes your client may not be willing to sign it or may not be able to sign it. If that's the case, you can still file it and serve it. It will become effective 14 days later unless your client makes a written objection. And once again, that allows the court to schedule a hearing to determine whether the limited scope representation has in fact concluded. Other changes to the Michigan court rules. We have changes to the service and filing rules that we already talked about in the section on the rules of professional conduct that will require other lawyers to serve both the limited scope client and the limited scope attorney with papers during the course of the limited scope representation. Finally, in section 6.001, the scope rule, we have a specific clarification that the limited scope representation provisions that we've discussed apply only in civil proceedings, not in criminal proceedings. The ghostwriting rules, they apply in criminal and civil. Limited scope representation, for now anyway, only applies in civil. That's all I've got for you folks. Thanks for listening, and I hope to see you soon.
Hi, I'm Barbara Baker-Omrod. I have a private practice in Owasso focusing primarily on family law and estate planning and probate. I'm really excited about the new court rules that are allowing us to have limited scope representation. I like to have unbundled services so that the people in my community where my office is, a lot of people feel that they can't hire an attorney because they can't afford it. So if they need something, I can help them on a as-needed basis to do some documents or something like that with a flat fee. The courts can't really help people if they're trying to do their situation without having an attorney, and they try to get through the court, and the judge is trying to get a judgment entered, and the judge obviously is not able to practice law and advise the client on what to do. If you have your documents set up so that you can do a flat rate for the complaint and those initial documents, that is very helpful to people. And it also helps that they can see that there are attorneys that can help them without being overly expensive, and find out that a lot of attorneys are not expensive anyway, and not nearly as expensive as they thought. It can cost people more money to hire a document preparer than it would cost to have an attorney draft the documents. Flat fees for the complaint, initial documents, temporary orders, and or judgments based on typical hourly rates make good business sense. If you were going to charge somebody that amount for doing those documents anyway without a full representation, you're not losing any money by doing them in a flat fee in unbundled service situation. When you do this, people learn that attorneys don't necessarily cost as much as they thought. People realize that attorneys are worth the money, and undercutting document preparers, if they are unscrupulous, helps everyone. Helping people navigate the legal system piece by piece helps keep a practice going, and it really turns into future business when people unfamiliar with decent attorneys realize sometimes attorneys are less expensive and are very decent, nice people. It is intent of the State Bar through its limited scope representation work group to create a comprehensive limited scope representation program which supports a referral mechanism to promote best practices. These videos contribute to that goal, but there is much more to come. There will be sample forms to include, scope of agreement, engagement letter template, client-informed consent template, limited scope appearance templates, appearance in a case and appearance for communication outside of a case, withdrawal of appearance template, conclusion of representation form letter. For the State Bar members, voluntary free online education opportunities regarding the limited scope representation on ethics, forms, successful business models, best practice tips, avoiding grievances, which is awesome, just to name a few. Consumer education will help with informing the public of the availability of the limited scope representation and benefits of taking advantage of lawyers offering this type of representation. To ensure that you stay informed and can take advantage of all of the information to follow on the limited scope representation, I encourage you to sign up for the State Bar alerts that will be issued by going to the State Bar homepage at www.mishbar.org. Look under News on the left-hand side of the webpage and then click on the Limited Scope Representation Rules adopted by the Michigan Supreme Court. This will take you to the State Bar's webpage that has the link to sign up. I hope you find this information helpful to your practice, and it's been great talking to you.
Thank you for your attention to this video and your interest in limited scope legal services. As Barbara Baker Omerod noted, the State Bar has convened a new work group to develop additional tools to help the bar, the bench, and members of the public understand and implement the rules. Please make sure to check the bar's website for new tools and more information on how these rules will help us serve the public in new and better ways. Thank you.